Trademarks. In this short video we will look at the rules regulating and protecting the use of trademarks. An example of a trademark is the distinctive name of a soft drink and the logo on the can of soft drink. A trademark is a distinctive mark used in commercial dealings to show a connection between a particular business and its product. It is a way for a business to distinguish its products from those of its competitors. A trademark can be letters, for example BMW, a word, Coca-Cola, a name, McDonald's, a device, such as the Nike swoosh, an aspect of packaging, such as the distinctive silver foil used to wrap up Philadelphia cheese, a shape, a color, a sound, or even a scent. Trademarks are regulated in Australia by the Trademarks Act of 1995. In order to gain protection under the legislation, the trademark has to be actually registered. Statutory protection of trademarks is not automatic. In order for a trademark to be registered, certain requirements must be satisfied. The trademark cannot contain a prescribed sign. So, for example, the Australian coat of arms cannot be used in a business's trademark. It has to be able to be represented graphically. In other words, it has to be capable of being described on a page. It must be distinctive. So, as a general rule, one cannot use commonly used terms as a trademark. So, for example, a fruit and vegetable shop could not register the term fresh fruit as a trademark because it's simply not distinctive. It cannot be scandalous or contrary to law. So, as a general rule, one cannot register as a trademark a swear word or a racist or offensive term. It cannot be likely to deceive or cause confusion. So, you can't use words that are going to trick customers into buying your product. And it cannot be identical with or deceptively similar to another pending or registered trademark. So, for example, if I was in the business of manufacturing and selling laptops, I would not be allowed to register the word Apple, spelt with a U, as a trademark because it would be deceptively similar to Apple. A trademark owner only has the right to restrain others from using the registered trademark in relation to the class of products for which the trademark has been specifically registered. So if you follow the link on the page, you will see that there are 30 plus separate classes of goods and another set of classes of services, and the trademark has to be registered in relation to one or more of those classes of goods and services. And the business that registers the trademark can only stop another business from using the trademark in relation to the sale of goods or services within that classification. So it's important to note that trademark protection is not the same as copyright protection. The owner of a trademark does not have the right to stop anyone else from using or copying that particular trademark, but they do have the right to stop them from using that trademark in relation to the sale of particular classes of goods and services. So, for example, Apple could stop me from using the word Apple in relation to the sale of my own laptops, but it could not stop me from, say, opening a restaurant called Apple. The exception to this is if the trademark is well known in Australia, in which case the trademark owner would be able to prevent someone from using the trademark in relation to unrelated goods or services. So, for example, in Virgin Enterprises and Clapsis, Mr. Clapsis attempted to open a car hire business and call it Virgin Car Hire. Virgin Enterprises, owned by Richard Branson, was able to prevent Mr. Clapsis from doing that, even though Virgin had no intention of opening its own car hire business under the Virgin name. As long as they keep using the trademark and continue paying the periodic renewal fees every 10 years, the trademark owner can renew registration of their trademark indefinitely, which is how many famous trademarks have been able to remain registered for many years, such as Coca-Cola and BMW. And while the use of a trademark symbol is not essential, it will prevent the trademark from entering the public domain. If a particular trademark becomes so commonly used as a general term that it is no longer distinctive, then the trademark registration won't be renewed. And so businesses that want to prevent their well-known trademark from becoming so well-known that it becomes a general term will usually insist upon using the TM or the R symbol next to their trademark to constantly remind people that it is in fact a registered trademark. Trademarks that have entered the public domain because they have become very commonly used words include escalator, linoleum, nylon, and other examples in the textbook. If another business markets its products using a trademark that is substantially identical with or deceptively similar to a registered trademark, it will have infringed that registered trademark. A trademark that is not registered under the Trademarks Act will still be able to be protected, but rather than use the legislation, the owner of the trademark can use the tort of passing off as an example, or Section 18 of the Australian Consumer Law, which, as we saw in earlier topics, prohibits misleading or deceptive conduct by a business.